Welcome to the Krinzman Property Playbook, your inside look at South Florida real estate. I'm your host, Matthew Krinzman, bringing you real strategies, real insights, and real connections that help you buy, sell, and invest with confidence. With over 2 decades of experience as a licensed realtor and broker associate, I've watched South Florida grow from a quiet getaway to a global destination, and I'm here to help you navigate it like a pro. My business thrives on trusted relationships, with many of my clients being repeat and referrals. This podcast is brought to you by me, Matthew Krinzman, a Sotheby's International Realty agent. For more info, visit buysellmiamire.com. Let's dive in.
All righty. Hello, everyone. Welcome to the Krinzman Property Playbook. I am your host, Matthew Krinzman. I am a real estate agent here in the South Florida area, based out of Aventura. I've been doing it for a very long time, and I got this podcast, to talk with people, interesting people, and people who can bring some good knowledge and information to those in the real estate world and even outside sometimes the real estate world. So today I have Patrick Russell joining me. You are a Miami-based mediator with Salmon and Dulberg Dispute Resolution. I think that's the whole title, correct?
Correct.
Patrick, just tell us about who you are and what you do, and then we'll kind of dive into it.
Well, thank you for having me, Matt. I'm a full-time mediator, as you indicated, throughout the state of Florida. So certified by the Florida Supreme Court in civil circuit as well as county court mediations.
Okay.
I handle all things civil from A to Z, which also includes your area and genre of real estate.
That's good.
Also related to that, I guess, somewhat is construction. So construction, real estate, handle those as well. Also a Florida Supreme Court qualified arbitrator. So the difference between, I guess, a mediator and an arbitrator, for those that aren't aware, a mediator doesn't make decisions. Mediator helps you all make decisions about involving your case. An arbitrator decides. So it's an informal process akin to court, similar to court, but slightly different. It's supposed to be more efficient and faster and less expensive.
Less expensive. Yeah. Just out of curiosity, just how long does normally a mediation case take to resolve or get done?
It varies. There are some mediations in highly complex multi-party cases that could go on literally for weeks.
Yeah.
But for the most part, they tend to get done in a day, whether it's half a day or a full day. Some could take as short as an hour. It all depends on the particular case and the motivation of the parties.
Great.
It requires both parties to be willing to resolve. If one party doesn't want to, which is their right,
sure,
it could be over really quickly, right? For mediation.
Yeah, I get to walk in and the answer no, I'm not doing this today. I'm not going to agree to anything. And then what? I guess they go to the court system at that point. They'll go back into the court, and that could cost a lot of money for someone. So I guess a mediation is kind of a way to expedite the process and get to everyone to a resolution quickly as possible and as cost efficient as possible, I suppose, as well. So you're not piling up the attorney fees. Yes, that's a plus if you're especially either on either side, and obviously you don't want to bleed money. So when you work as a mediator, how does this work? How does this apply to my world and those who are listening or watching the real estate world?
Well, you'd have to think of all the different conflicts that could arise in the real estate setting.
Sure.
I mean, it could start with landlord-tenant matters.
Pretty simple.
So it's between landlords and tenants, whether it's eviction issues, it could be damage issues, it could be return of deposits, anything related to that real estate lease could be subject to a mediation. But probably more common than not in your field would be disputes over real estate sales.
Sure.
And that ranges from one party claiming the other party breached.
Yeah.
In time, the payment of a commission.
That's a big one.
Return of a deposit.
Escrow deposit we're talking about normally. Yeah.
So commissions, deposits, breaches, who gets what, does a sale go through or not? Those are also very, very applicable.
Yeah. I have to go back and look at our, the normal FAR bar contracts. They do state, I think it's mediation. It's usually the course to come to a resolution if there is a dispute, especially on the sales side. If the buyer or the seller don't perform, rarely, escrow disputes obviously have a whole different level of things. You have to make a claim, and then you have to put it to with the state. With FREC, you have to make a notification to FREC, which is the Florida Real Estate Commission, if anyone doesn't know exactly what that means. And then guess what? Then you have to put the escrow with the court. Is that it? You have to put that, make a dispute and put it with the court system. And then I guess one way of avoiding it is, having to go to court is to go to mediation, decide who split the baby, essentially. Like, all right, who's going to get X amount from escrow to get this done if they can't get to a resolution beforehand. Usually I've had these cases. I've had it happen a few times in my career where there was a bit of a dispute, but a lot of times good attorneys get together and they're like, hey, let's just figure this out. And let's get it done. And usually there's some penalty, incurred by either the buyer or seller for performing, but I've yet to ever get to mediation. I hope I never do personally, but I mean, just take us through what would be, as far as an escrow dispute, what would be your role in deciding how to come to a resolution?
Well, one of the unsaid advantages so far that we haven't talked about for mediation, you've spoken and directed the conversation towards efficiency and costs, which is very, very true. But also the other power is self-determination. So the parties being able to resolve the dispute on their own.
Right.
Courts generally are black and white.
Yeah.
There's only certain things they can do by statute or by law. In mediation, you can craft your own agreement that you can do things that a court couldn't do. So you can get creative there. That's one thing. So self-determination, solving it on your own, because you're also managing risk.
Sure.
Really speaking, when you go to court, it's all or nothing. One party wins, the other party loses. So here you can manage risk by trying to make a deal. Doesn't necessarily have to split the difference. Sometimes that's what people do, but it doesn't have to be that way. So managing time, risk, money, efficiency are very, very important in terms of what mediation does, as well as being able to, when you want to craft your own solution, like I indicated, you can really up the ante in terms of how you do it. And there's a real power in that, and the parties can get together and figure out those creative solutions.
Yeah.
So it through an escrow, what would be my role? Again, it's apprising people. My main goal as a mediator, first and foremost, is I'm a neutral. Well, I do not favor one party over the other. I'm kind of the guide to the whole process. My goal is to help both parties consider their options, consider their risk, and then make a decision, good, bad, or indifferent. It's up to them what they do. I don't make the decisions for them. So I manage that process with them.
It's kind of like you're trying to get to a fair resolution, something that's fair for both sides. They may not love it at the end of the day. Both sides may not love what it is, but it's going to be like the most fair way of resolving any issue they may have that comes up. It's, both parties are going to come away like, well, I didn't get everything I got, but I got something. So that's fair. That's something I always try to use when I'm talking to people about making a deal. It's like, well, let's just make something that's fair for everyone at the end of the day, especially when they're loggerheads, right? When they're just butting heads like rams on a mountain with each other and they're not getting anywhere. I'm like, look, let's just get to somewhere where it's fair. You think it's fair, they think it's fair, and we're happy. You're kind of happy. Not going to be 100% happy, but you'll get it done and you'll move on with your lives and you'll get the deal done. You've practiced law for about 30 years in general also, but are you just solely working as a mediator, or do you also get into do you also do, litigate or go into litigation as an attorney or as well?
I made the transition about 5 years ago to mediation and arbitration full time.
Okay,
That's
good.
all generally speaking, if you want to really get good at something, you dedicate yourself in one direction.
Sure.
Having one foot in the boat, right, and one foot on the dock.
Yeah.
Is not the safest place to go. Speaking about splitting the differences, right?
Sure. Yeah.
But the idea is that you want to really be fully dedicated to this type of profession, and that's what I do.
Right. It's like you're being a professional. This is your profession. This is what you're professional at. This is what you're good at. and this is all you want to do or you want to be doing. So yeah, that makes sense. I mean, look, that really kind of applies to anything in life, really, right? It's, if you're going to be a great basketball player, or a great pianist, you have to practice a certain amount of time and dedicate your life to just doing that. So yeah, good for you for making that transition from being a lawyer full-time to being a mediator arbitrator full-time the last 5 years. So yeah, if someone's looking for experience, I would probably say, yeah, I want the person who does this only. I don't want the amateur necessarily. No offense to anyone, but the reality is there's a difference between being a professional and being an amateur, and you want a professional on your side, or at least helping you decide how to get to a resolution. And that's your role. We talked, obviously there's a difference between litigation, the difference between arbitration. Arbitration is more strict, right? You're deciding, you're like, hey, this is the way it's going to be, and that's it, right?
Correct.
So
based on, it's a proceeding in which the parties would get together and still prevent evidence. It could be by testimony or documents.
Yeah.
And it would be upon me then to decide as an arbitrator which side prevails based only upon the evidence submitted. I do not go outside and try to figure things out on my own.
Right.
What you provide, and based on kind of like a real estate contract,
Sure.
those four corners, who prevails?
Well, the real estate contract, but everyone's like, it's flexible. There's, it's everyone, it happens. I mean, look, someone's going to interpret it a different way, or they're going to like, well, that doesn't really matter. We'll get past that or figure it out. But it really isn't like it's black and white. There's no gray area really for you at that point. How different is that really from then going before a judge, in that case?
It tends to be faster.
Okay.
Judges have a lot more cases.
Sure.
You're operating under the Florida rules of civil procedure in court.
Okay.
The parties can or cannot agree to do that in arbitration, but generally speaking, it's more relaxed.
Right.
It's quicker. So arbitration proceedings tend to speed up the process. There is what I would call, for the most part, unless the parties agree, limited discovery. So discovery is doing depositions, and document requests, and interrogatories, which are written questions. So there's limited amount of that in arbitration. So it just tends to be a lot more relaxed and informal. I'm not trying to downplay it and say it's like an easy thing. I mean,
right.
The court, it's a whole different ball game, and people tend to like it. However, I would say also there's been kind of a push lately for arbitration to become more complex.
Really?
Makes people scratch their head and go, well, it's getting closer and closer to being court. So what are the advantages now?
Right.
So we have to be careful with those changes that are happening, making arbitration more like court. That would just be my own personal opinion.
Right. So then it kind of defeats the purpose of it, right? It's like, well, then what's the point of having arbitration? You're just basically doing a court case. You're basically back in the court at that point. So getting into the real estate side of what you do, can you run us through, I mean, you obviously can't name names or anything, but all right, how about this? I have a commission dispute. There's always, in the real estate brokers have, procuring cause. And, I've seen cases where a deal happened, but the commission, the agent who may have introduced the deal or introduced the parties to this transaction got frozen out somehow, was not there. And I say, hey, you know what? I brought you guys that deal. We had an agreement. I'm owed a commission. And they say, no, you're not. So how do I get to a mediation point? How do I end up in front of you to get this?
It all depends on the contract, first of all. You mentioned early on, what does the contract provide? Does it require mediation first, or is there a lawsuit and then the parties request mediation through the lawsuit? So that really the first step is depending on the contract.
Okay.
I mean, I've had cases just like that, and they're very, I would say, fact specific and very contract specific. So what does the contract say about the commissions and splitting and procuring? And then what evidence is there in support of that actually being true?
Right.
And what's the dispute really about? And then you get into risk assessment. Well, can you prove it? And not necessarily can you prove it, but what jury will believe who? So it's not necessarily what you can say or show, but what you can prove and what a jury will believe. And so we have that analysis during mediation.
Okay, so now we have a procuring cause issue. What about now? You said you do a lot of construction deals or mediation on construction. What would that entail? How that get to you again? How would someone with a construction issue or whatever it get this? And maybe you can give some example of that.
Sure. So typically the typical case I would see that would be construction related would be a dispute between a general contractor, a subcontractor that the general contractor hired. Maybe they install doors, let's say, or they're pouring concrete.
Yeah.
And then the owner. So the owner could also be involved too, because the general contractor and the owner have a contract, which they have to pay X dollars for an entire completed project.
Sure.
The owner may decide he's withholding payment because he doesn't like the way the concrete was poured. And that holds up the entire deal. And then the general contractor decides he's going to go after the subcontractor. Hey, I'm not paying you what you're owed because you didn't complete the deal. And you have a three-way battle going on. So those type of disputes, let's say. So they normally would get to me after a lawsuit.
Oh,
and
yeah.
So they're pending lawsuit, and then the parties go to mediation to see if they can resolve it. If they can't, then it's off to court. They go for a trial.
Well, how about this? When obviously we have a lot of new construction, we have a lot of new development here in South Florida and Miami and Brickell, especially on these high rises. And I, as a buyer, come in, I came in and I bought it pre-construction, property is now built, and as there are defects everywhere I look, and the construction build and the quality of the unit. And actually, we can get into even the structure of the buildings, but say as a unit, I bought the unit and now there's just defect after defect. There's leaks, there's everything. What remedies do I have to get the developer, the person who built it, and then I guess I have to go to the contractors, the builders, and the contractors. How do I get resolution? What do I need? What are the steps? I need to file a lawsuit. What to get to mediation? What is it? How does that get to you?
Well, one of the benefits of being a mediator and then having nearly 30 years of legal experience is that all my legal experience helps me be a mediator.
Sure.
And so here, again, it's contract. So first step is always to analyze the contract. What does the contract say that your remedies are? How do you exercise those remedies? There's some contracts that require that you go to mediation first before you can even file a lawsuit.
Right.
If you jump the gun and file a lawsuit first, a savvy defense lawyer will file a motion to dismiss saying that there's no standing for you to do this. You fail to do a condition precedent, which is to have mediation. You failed to do it. So the case may be dismissed, or at least it will be stayed pending mediation. So nothing will happen until you go to mediation. So that's the first step. Analyze the contract, what needs to be done, who's the claim against? Typically speaking, in this instance, it's going to be the seller, whoever that is, the developer, I assume. It would be up to the developer if they feel that, hey, we did what needed to be done, and maybe we needed to bring in the subcontractor as a third party and make them liable for these mistakes. But also, a lot of this could be addressed by doing your famous punch list items, right? Being aware of doing that final inspection with a fine-tooth comb and figuring things out. I guess the tricky scenario is where these defects are hidden. So there is in the wall, there's a leak or there's an electrical problem.
Sure.
You can't see. Then we have the dispute that we're talking about.
I mean, you see it now also just on the buildings themselves, where the associations, once it's turned over, are now suing the developers and the contractors because of the defects. And you see that all over the place. There's always, every new building has, I forget the name of the lawsuit, but there's a lawsuit that always gets filed in the courts for these new buildings to whatever the remedy, to get the developer to whatever deficiencies they had on the builds. And, that's a little bit of an issue, but usually I see them get resolved. But do they more like those type of deals where it's the whole association suing, taking on the developer and the contractors? Would those end up with you, or do you think those end up more in litigation? Or is that, again, process or to litigate, you go to court and say, "Oh, look, you got to go to mediation first to get this resolved." Is that this? Is that
More likely than not, it's the first one where it's filed first with the court and then it's mediated.
Got it. Would any of this come up in the arbitrate? Would this go to arbitration at all ever, any of this? Or is this usually?
It depends. More and more that arbitration is being pushed heavily now in contracts because I guess, savvy businesses don't want to be tied down in court and rather go to arbitration. So more and more often than not in commercial contracts, you're finding arbitration clauses.
Mhm.
That would be monitored through the American Arbitration Association and all of its formal rules and procedures.
What are the steps? If I'm like, hey, I'm going to go to mediation, and what are the steps? What are the things that I need or anyone else needs to bring to you, the mediator, at the time of mediation? Or is there the documents we need to assemble, or is it, like a docket, like you have in a you put all your files in together and then you review the files? How does that all work?
Well, generally speaking, if you're represented by a lawyer, which is probably 90% or more of the time,
Yes.
the lawyers would be handling this. So generally speaking, the lawyers would send me a mediation statement in advance, which is basically a summary of the case from their view. And obviously, when I get one from the other side, it's going to be slightly different, right? That's why we have a disagreement.
Mm-hmm.
So that's the matter of perspective. So each side, even though it's the same case, set and circumstances, they're seeing the case differently.
Right.
So they will hone in on those differences, or at least I will identify them with these documents. And then we arrive at mediation. And in terms of preparation for mediation, I mean, it's obviously the lawyers should be meeting with their client to tell them what mediation is, so they don't show up not knowing what's going to happen.
Sure.
So advising them, this is basically mediation is a negotiated settlement. That's all it is. They're to negotiate. We're not here to prove points. This is not a decision being made by the mediator. So you need to know what the purpose of mediation is. Also, you need to know that it's okay to make concessions during mediation.
Sure.
You have to advise them that, because
Right.
otherwise, if the lawyer starts doing what they do, which is negotiating, and the client doesn't know this, they may think that their lawyer is caving on them.
Yeah.
Oh my God. So he doesn't believe in my case, because why would he be giving up an inch?
Right.
But if you explain to them your strategy, so I'm talking about the lawyer, is explaining to the client that what the purpose is and what we're doing and why we're doing it, they'll be in a better position. So they need to manage their expectations. They need to have a strategy in terms of where you're going. So what's your maximum you're willing to pay out to get out of this case?
Yeah.
What is your lowest you're going to take in this case? Have that set up and have a strategy of how to get there. Just don't do it willy-nilly.
Yeah. I'm nodding in an agreement a lot of what you're saying, because it's very similar to what I do in a way when I'm brokering a deal. We're negotiating. I'm negotiating with the other broker or the other agent to get to a deal that all parties can be happy with, or, live with at the end of the day. And there's give and take, obviously. You're going to give a little bit, we're going to take a little bit, and we're all going to get to somewhere in the middle where the sign on the dotted line, and we get into the transaction, we get to the contract, and hopefully we get to the closing table by the end of this, and everyone, keys are exchanged and checks are exchanged and everyone walks away happy. So it's like when you said manage expectations, that's really, when people ask me, what do? I'm like, I manage expectations. I really do. I manage it, like from pricing a property to negotiating the property to compensation. I was gonna say commissions, but now that's like a naughty word for us for some reason now after a lot of litigation, but so compensation. And these are all things that are negotiated all day long. And then even up to the day of closing, sometimes you're saying something pops up. Oh, well, we need this now. And okay, now the back, again, it's never done until, like I always say, it's never done until the checks have cleared, basically.
Mm-hmm.
So it's very similar to what we do, what you're saying, especially the expectations part. Boy, that's been my life for 27 years, at this point. So I love when you said that. And it's I'm like, wait a second, this sounds a lot like what I do on a daily basis. So we have, it's a very similar, but what you decide, that's, so when you decide, is that you make the decision for them? Is that it? You don't actually know. You said you don't make the decision for them. You get them to agree to a decision. And then once they agree, what happens then? What do you do then? And when they get
I assist them. Well, first of all, one of my main jobs is to make sure that in terms of the idea of self-determination, a party is willingly doing something,
right,
that I need to confirm that that's the case. Because a lot of times this may be the first time a party's ever gone to mediation. This may be their first legal case.
sure,
All of this can be seen really confusing, especially if it hasn't been well explained to them. So that's one of my main jobs, is to confirm, okay, are you aware that this is the amount that you're settling the case for? And these are the terms and the conditions. And you're okay with that. And you're also aware that there's no going back. Like, the case is over. If something should change on your end, it doesn't matter. You got a signed agreement. This is what you've done. So I got to confirm the terms of the agreement to make sure everybody's on board. Then I encourage everybody to obviously reduce that at least to a settlement agreement while we are there. So we use DocuSign. I help the lawyers draft something. I don't draft it per se. They tell me the terms and conditions. I have a form that we fill out.
right,
Then everybody signs off on it. And then we have what presumably should be an enforceable deal, because there could be nothing worse than spending all this time reaching an agreement. And then there's either buyer's remorse, or there's confusion, or there's no deal after it when everybody thought there was one.
I've been there. It's I've been there. That's for sure. So you mentioned something in your bio about maintaining relationships, the idea that mediation should help do that. Can you expound a little bit on that for me and for us?
Yeah, that's also a valuable benefit. So especially, well, there's two examples between businesses. So if there is an ongoing contract, there's some sort of dispute, one party files a breach of contract. Think of it as a commercial lease, let's just say.
Sure.
Again, applying real estate. Landlord didn't do X, or hasn't done X, and we need X done, whatever that may be.
Yeah, an improvement that needed to be done for the property or something.
Maintenance of the property, that sense, but whatever it is. And one party is obviously very upset, and upset enough to obviously file a lawsuit over it. There's two ways that can go. You can resolve it and everybody goes their separate ways, which is a possibility. So that's kind of the nuclear option. Or you can repair the relationship and keep it going, because at one point it was mutually beneficial. The tenant needed a place to conduct their business. The landlord is more than happy to do so because they want rent. One possibility, that can't necessarily be a possibility in court in certain circumstances. The court says you breached, you're out, whatever it may be. In mediation, this is an example where you can craft a solution where you can continue that. Another one that's also applicable to real estate is where you have, and maybe you've run into this on your own.
Sure.
Where you have a family dispute over a joint owned property.
Oh, so now we're talking emotions.
Own the same property. Or it could be through a divorce, or it could be through inheritance, whatever it is. Something's going on and there's a dispute over ownership of that property. One party wants to sell it, maybe another party doesn't.
Yep.
Whatever's happening. Again, they're called partition actions. We want the other party out. We're willing to, we need the people to pay each other whatever the benefits would be, and we want to take it over. Again, a court, black and white.
Yeah.
One party wins, one party loses. Here's the dollars. Goodbye. See you later. In mediation, maybe we can solve and go over some of those hard feelings. So whether it's a family or even business partners, you can still continue on and say hello to each other where it doesn't become total war. So mediation offers that as a possibility. So I do a lot of, think about it. Sometimes it's almost psychology during mediation. With emotions.
100%. There's, especially when you get into a familial issues, like you just mentioned, inheritance, or even divorce or things like that, where it's all emotions involved, right? And you have to balance the parties, you have to balance their emotions, and you have to find that middle part where the parties can come to an agreement and agree on and move on with their lives. Look, I've seen it in probate, especially where if they didn't have, if the deceased did not have a good estate plan or things like that, you end up in the probate courts. There's always one party or two parties involved. Like, I don't agree. And it becomes a mess. It becomes a problem. And you end up in litigation, unfortunately, or hopefully maybe they're smart enough to like, hey, let's stay away. Let's go into mediation and try to resolve this amicably as best as possible. Like you said, to help maintain a relationship. Because I've yet to ever see someone go to court and come out friends at the end of the day. It doesn't happen, unfortunately. In any case, in any of those, rarely, but mostly, especially in any familial type of situation, the bonds are broken pretty much, and there's no repairing them, unfortunately. But I like what you said about a mediation. It's like you're imagining you're becoming a psychologist in a way, which a lot of times people say like, oh, real estate agents are psychologists. Yeah, sure. We have to balance people's emotions and find the rational and find, how to balance all that. Cause when someone's buying a home or selling a home, there's always some emotional attachment involved in it. So you have to kind of help bridge it. But I like what you said about, mediation. There's a lot of similarities, but especially helping families not split apart. If you're capable of making that happen, then phenomenal. Cause I would say stay out of the courts for 100% because it's not going to be pretty, unfortunately. I like what you said that. So when is mediate as an agent? Is there a time I can recommend mediation, or is that again still kind of I'm out of that, or can I do that?
Well, if you're representing a party and there's a dispute, I would assume that they may look to you first before a lawyer.
Yeah.
So they may ask, well, what can we do? And depending on the contract, you say, well, what does the contract say? It has to be done by X means within X days. So you got to follow the contract.
Sure.
Whatever that may be.
And you can also prevent a deal from falling apart. Well, you mentioned that as far as a lease term, but as we're negotiating, a complex transaction, and it's just, everyone wants them to get a deal done, but they can't get the deal done. Can we call you? Is someone going to say, hey, Patrick, I need you to come in and help get us to a resolution to get this deal completed? Is that a possibility in your?
Yeah, there's been a push now, something called EDR, which is early dispute resolution.
Okay.
That is using mediation before there's even a lawsuit, and the parties getting together saying, well, we don't want to go through that whole process. So let's try to see if we can resolve it with a mediator first. Or they agree, okay, fine, we need to still file this lawsuit because there's a deadline. We have to protect our rights. We're going to file it as a placeholder, but immediately we're going to go to mediation to see if we can try to resolve this case before we have to spend and do all the heavy lifting of what goes through when you file a lawsuit, the discovery, the depositions, all that stuff. We're going to put that off and see if we can do it with mediation first. So yeah, you could do that. And that's something that's actually becoming more exciting in our field, is to actually do this, which I'm all in favor, because less lawsuits, right? Less money spent, tend to be better results, I would think, because at the end of the day, both sides are paid for lawyers. It could get quite expensive.
Sure.
That in mediation, fantastic.
Yeah, because the lawyers are billing you per second most of the time. Yeah, it's like, even if they
and I'm a lawyer.
I know. That's like, look, it's like you think like, I get a bill from an attorney, like, but that even you thought about me. Oh, okay. Yes, I got to pay that bill. Like you thought, I felt the force and the disturbance in the force, and that you thought about me. So I had to bill you 5 minutes or whatever it is, incremental, or 15 minutes or something like that. But yeah, it's really a cost saver. That's really, because attorneys are expensive, especially good ones, in this town where you're looking at maybe $600 an hour on average, which is not cheap. And if you can save people money like that, then I'm all for it.
And remember, the lawyers would presumably still be involved in the first start of early dispute resolution.
Sure, they're there still.
It's not like I'm advocating taking work away from lawyers. It's more refocusing their efforts to finding a solution first, before doing those other things, which again, I consider to be the nuclear option.
Right. The nuclear option, which we don't want. So how does someone decide, hey, I'm going to use Patrick, I want to go to Patrick Russell for mediation? I mean, who are your best friends in this community, in this world, to bring you business or to come to you for any type of resolution, for dispute resolutions?
Primarily lawyers are. So primarily lawyers are my clients. They're the ones that are hiring me on behalf of their clients.
Got it.
Because lawyers are always representing clients, and that's who we see at mediation. There are some instances where there's what we call pro se litigants. Those are folks that don't have lawyers.
Okay.
So they file their own lawsuit and they represent themselves in court. Infrequent, but it does happen from time to time. But that's a very small percentage of cases. So again, it's primarily lawyers. They have their own lists and favorites, I guess, and
Sure.
who I work with.
It's like us, agent, we have our favorite attorneys we like to work with. As far as for real estate closings, we have our favorite inspectors we like to use, mortgage brokers that, we rely upon for business or to exchange business with, and we rely on to advise our clients and our customers correctly and what they're doing. So there's a trust factor, obviously, that has to get built up over the time. I mean, I'm sure your 30 years of being an attorney locally, and then out the 5 years you're doing 5 years as a mediator, you've built up some pretty goodwill over these years with other professionals like yourself in the legal field. So that helps, obviously, and having a good reputation,
we would hope,
goes a long way.
So yeah, well, one of the things that's also good to have as a mediator, and I do have that, is I work on both sides. So that means I represented plaintiffs, people filing the claims, and I've also been on the defense side. So defending types of claims. I've sued insurance companies, but I've also defended insurance companies. Those are very different rooms to be in, whether you're a lawyer or even as a mediator, when I go back and forth dealing with those two rooms. So having experience from those two perspectives is also very, very
You mentioned insurance, and that's one thing I wanted to add. So do you get a lot of where disputes between homeowners and insurance companies? I'm sure in Florida, it has to, where the land of it. I mean, this is ground zero for the most part, but do you get a lot of those type of mediations coming before you?
And I used to do that work as a lawyer.
Oh yeah.
So as a result, I get a lot of that work as a mediator.
So you're known on both sides.
First party property cases is
right.
the term for them.
Yeah. So you're known both on the defense and the plaintiff side of that insurance world. So that's great to have that connections, because like you said, you did work on both sides. You've done over the years, you did both sides as an attorney, and you're known. So again, I guess these are all things that help. It's like, again, being a good agent and, and doing good, that you have a referral base or someone who trusts, like, hey, we trust him. This is who we trust. This is who we would do all our business with. Let's get before, either have Matthew as your agent or get Patrick, as your mediator, and they can select the mediators. Is that correct?
Yeah. Well, both sides have to agree, obviously. Okay. So it's got one person that I need to convince to use me, right? It's both.
Well, just how do you do that? Just out of curiosity, how would you convince both? Like, hey, I'm a really good guy.
Again, like what you said, it's by your reputation. It's by your willingness and hard work. This is not a job where you just phone it in. You just show up and you go back and forth with a yellow pad and what's your number? What's your number? What's your number? And then there's no other discussion. Then you go home.
Right.
There are people that do that. All right. But that's not really, in my mind, the best way to do this. Because you need clients on board. They need to know there's a bigger picture. There's risk assessment, risk management issues. There's the emotion component. Just getting people on the same level emotional feel to start the mediation is super important.
Right.
And if you just show in there and start running around with a yellow pad, you're not diffusing that situation at all. So you need to basically be able to communicate and work with people on their level, wherever they are. And if they're in a bad place, hopefully elevate them and get both sides in the same plane where they start working with each other. Because again, it's their process.
Right.
You get them working and collaborating and communicating together, and they treat this as a business problem. rather than an emotional problem and a fight, because that's a different part of your brain. If you get them
100%. Yeah.
you're in a
100%.
better position to solve problems. So that's kind of what I do. And hopefully people appreciate that and use me for that reason.
That's a great way to end. By the way, that was a great way to tie it all up into a nice little neat bow. I really appreciate all that and bringing your knowledge and your information as to what a mediator does, what you do as a mediator, and helping people come to a resolution, manage the emotional aspects of it, get people to a middle basically where they can all live in, I guess, peace. Well, I mean, peace and harmony, but where they can be happy for the most part with what the resolution is and move on with their lives, whatever it is, and especially in real estate, to get the transaction completed or get a resolution on a construction defect where the person who I spent a lot of money on building a house or building a building, and I can have quiet enjoyment of my home. And all those and the issues have been resolved, hopefully, and amicably, and done in an efficient time, which I like to say is like, it's all about efficiency, cost management, and emotional management too at the same time. How do we find you? How do we find you online or or outside in the world, Patrick? How do the people find you?
Well, there's like 3 or 4. I mean, one is through my employer, so where I'm on the panel. So Salmon and Dulberg, which is sd-adr.com. I have my own mediation website and blog. I write articles for lawyers and clients, how to better prepare and have a meaningful mediation. So that website's called meaningful-mediation.com.
Great.
All my contact info is on there. And then obviously on LinkedIn as well.
You want to give a shout out to your nonprofit as well that you wanted to talk about? Just give us a quickly.
Thank you for that opportunity. So I do have a nonprofit. It's called the Making History Project. So it is a veterans oral history project where I interview combat veterans from all eras. I started primarily with World War II veterans.
Right.
Our oldest generation, their stories for their family.
That's amazing.
And themselves. And then it's also sent and archived with the universities and the Library of Congress. I started that in 2014, and I partnered up with the University of Miami.
Awesome.
Where we had our first Veterans History Project the last year and a half or so now. So,
and is there a website or anything that people can get to check it out?
That's called making-history-project.com. And it's got its own YouTube channel where you can see a sample of the interviews that have been conducted thus far. That's
great. A great way to preserve people's memories and history that, I mean, obviously there are ways of doing it, but there's growing up, we had PBS, we had the World of War and things like those type of documentaries, but to have actual testimonials from men and women who served this country, and were in combat, I think it's a great history project. Again, I really appreciate your time, Patrick. Go Canes. Hopefully we get into the playoffs, and I would love to see you play Notre Dame again if we get to the playoffs. That would be a lot of fun. And got it. Anyway, but let's hope for the best. Let's have a great Thanksgiving and a great New Year coming up, successful one. And may all your mediations be smooth and not too complex and not too emotional, and everyone is happy at the end of the day. I'm your host, Matthew Krinzman of the Krinzman Property Playbook. Give us a like, give us a comment, check us on YouTube, Spotify, also wherever you catch your great, listen to all your podcasts. We would love to hear from anyone, and, please get in touch with Patrick, or definitely check out his nonprofit, making-history.com. I think it's a very worthy cause, and I thank you for doing that. That's awesome. And thank you for what you do. I mean, that's, helping us in the real estate world and also outside the real estate world get to, resolutions that work for everyone. And be in touch, and thank you everyone for joining us today.
That's it for today's episode of the Krinzman Property Playbook. I hope you've gained some valuable insights and feel inspired to take your next steps in the real estate game. If you're ready to make a move or need expert guidance, let's connect. Whether you're buying, selling, or looking to invest, I'm here to help you navigate the South Florida market with confidence. You can reach out to me directly through my website or on social media. Let's get the conversation started and make your real estate goals a reality. Thanks for tuning in, and I'll see you next time on the Krinzman Property Playbook.